I received and I reviewed the responses as well as the replies on the special exceptions and the motion to dismiss. Both sides ready to proceed?
Respondent's ready to proceed, Your Honor.
I'm ready.
All right. Joy, you ready?
Yes, Judge, I'm ready. Go ahead. Thank you.
Your Honor, Matt Garcia for the movement, the Dallas County Domestic Relations Office.
Melanie Sanderson Love, Your Honor. I'm representing Sarah Poland.
Peggy Pasquini, I represent David White.
Thank you all. And we are here from a reset on Monday for the Domestic Relations Office First Amended motion for enforcement. And we reset it to be able to entertain the motion to dismiss as well as the special exceptions, given that at the time that mother's attorney filed the motions and the special exception, it wasn't proper notice to the Domestic Relations Office. So this morning, what the court is argument specifically on the, I believe counsel when we were here on Monday, you said you wanted to start with the motion to dismiss?
Yes, Your Honor.
Okay, so we're going to take that up just so it's reflected on the court's record. The court takes judicial notice of all contents of the court's file, including the mother's responses to the first amended motion for enforcement, as well as the Domestic Relations Office replies to mother's responses. So Attorney Henderson Love, let me get you started.
Your Honor, we're arguing the motion to dismiss on the pleadings that were filed February of 2025. Ms. Poland was served with those documents in December, I believe, of 2025. And I'll make the argument as follows. The request is to dismiss the first amended motion to enforce because it fails to just allege what order it governs. We argue, Your Honor, that the provisions that is stated starting paragraph 7, it references two different orders, but more importantly, starting at paragraph 10 in the motion, it reflects amount that's prior to the order that they're trying to enforce. So it says a prior support arrears of December 31st, 2021, and it gives an amount, but it does not reference a specific order. So what we're asking is that for them to explain to the court which court order governs each alleged arrears period and what provisions of which order are alleged to be violated. We believe that the improper blending of these orders, that one order supersedes the other, yet is being referenced in the motion for enforcement by contempt. It's not an operative period, and it does not allege each time that there was supposed to be a payment and it wasn't a payment in referencing the proper order. We believe that there's a lack of due process notice, the itemized missed payments by date, to identify the principal versus the interest, to reconcile the payments credited through the registry, or attach the appropriate payment ledger. In this case, Your Honor, there's been multiple payment ledgers that has been presented by Mr. Garcia's office. And also, Your Honor, we're asking that it be dismissed because the motion to enforce in its entirety, and also dismissed because you cannot get contempt based on how the First Amendment has been presented to the court.
Thank you. Attorney Garcia?
Well, first off, there's no legal authority for the court to dismiss, and certainly not based on those arguments. As I pointed out in my response, there's only two methods for a court to dismiss a case brought under the Family Code, and that's lack of jurisdiction or want of prosecution. Those were not raised, and even if they were, the court has continuing jurisdiction, so that issue's out, and I'm prosecuting the case, so that issue's out. There's no legal authority to dismiss this case. End of story. All those all those arguments Ms. Henderson Love raises are evidentiary and can be addressed at trial. Those are not factors the court can use to dismiss a suit.
Your Honor, if I may respond to that, and I said reference this in our response brief. We never raised 91A, and we don't believe 91A. We don't think that's applicable here. We don't think it's applicable because we seek dismissal based on the amended motion to enforce because it fails to comply with Texas Family Code section 157.002, that if you're going to look for contempt, you have to show that a person, they have an affirmative duty to the court has an affirmative duty to dismiss or quash a contempt pleadings that do not provide constitutionality sufficient notice, and Rule 91A, as Mr. Garcia argues, is irrelevant to that analysis. Those are two separate things. We did raise it. That's no part of our argument. It's strictly we're moving on section 157.002, and it's very clear what has to be done. And if the state fails to do that, then they cannot get contempt, Your Honor.
Again, that's an evidentiary issue, not a pleading issue. That is not grounds for dismissal. And of course, it falls under Rule 91 because that's the grounds for dismissal. Period.
How is Rule 91A applicable, but 157.002 isn't, counsel?
Judge, there is no authority under 157 that says the court can dismiss the case because of a pleading issue. They can file special exceptions. They can file a motion to strike. Neither was filed here, except the special exceptions, but we haven't got there. But it doesn't say anything about a court dismissing a case. And she's talking about contempt. Contempt is going to be an issue for trial.
Well, the
cases I cited say that the motion is to give the contemptor, the obligor, notice of what the motion's about. We gave her notice of what the motion's about. She knows why she's here.
Well, I guess the specific for the court in particular, 157.002, it specifically outlines the contents of a motion for enforcement. It starts with possession and access, then it talks about child support. Then underneath child support, it specifically references if you are seeking contempt, you must show the amount, the date, the amount paid, and the amount due. I've looked at the First Amendment amended motion, and all I have seen is the amount of arrearages due, how much interest has accrued. I haven't specifically seen anything where it says an amount paid, if any, in the actual motion.
It's attached to the motion as my pay record, and as you saw in one of the cases I cited in the special exceptions, that very issue was complained on appeal on an AG's pleading. My pleading's an AG pleading, and that court found that the pleading was sufficient under 157, and that's why I pointed out that case.
For a payment record, because this specifically says the contents of the motion, not anything attached to the motion.
It's incorporated to the motion, and the court found that sufficient.
Your Honor, what Mr. Garcia is referencing is in courts have allowed a pay record, but I think he's confusing the two.
Ms. Henderson Love, I'm not.
Hold on 1 second, counsel. I'll let you speak. Go ahead.
Okay.
I think he's confusing the two. It is permissible for an attachment to be part of the pay record, but also in the body of the complaint. I think Your Honor hit on this, is that we still need due process and we still need notice of what is claimed to have been paid and not be paid. In this case, I will represent to the court. My client was not served with Exhibit C, Exhibit A and B, but I will reference it was part of what was filed, but she was not served with it. But even if she were, I still believe that it's deficient notice. It's deficient notice because even in Mr. Garcia's response, he does not address any of the pleading defects, okay, in the motion. How did she fail to pay? Her ability to pay. None of that is referenced anywhere in the motion. He does not dispute the factual insufficiencies. He does not address the competing orders that he's referencing. In which order is she deemed to have violated? Where is their order that's prior to, if we look at 10A, prior child support arrears as of December 31st, where is that? What order is that? He does not cite to Texas Family Code 15702 as I referenced. He, for the first time, raises 91A, which I believe those are two different standards. He does not respond to the due process or liberty interest. When you're talking about confining someone, you have to give due process, and he doesn't address any of those arguments. And he relies solely on procedural claims in the motion to dismiss. It's not allowed. It is allowed, Your Honor, when he fails the basic premise of the pleading requirement, that she is supposed to know when, how, where, how she failed to pay, what she paid, and when she paid. Where are the deficiencies of how she failed to pay a prior child support arrears as of December 31st, 2021? Where? How was she supposed to pay that? Where was she supposed to pay it? When he references a judgment, but then he doesn't say how it's supposed to be paid. So I just think the conflating of the motions, of the two orders, I believe he's actually moving on a void order. And if the court pulls back the layers and going back to the Court of Appeals, where it said that one of the orders was actually void. And Mr. Garcia is now referencing the order. The only order that was supposed to be before the court was what occurred in 2021. What Mr. Garcia is attempting to do is reference an order that's not applicable, referencing arrears that's not applicable, and is actually void. And for those reasons, Your Honor, we stand on the motion, our request for a motion to dismiss, an alternative motion to quash. And if the court is of the opinion that Mr. Garcia's motion is in due order, then we will move to our special exceptions.
Okay, Attorney Garcia.
I go back to my original argument. Ms. Henderson Love has no legal authority before the court for a motion to dismiss. None. She's just throwing up spaghetti and hoping something sticks on the wall. She's saying, I'm doing this, I'm doing that. She doesn't know what I'm doing. These are all evidentiary issues.
I'm speaking legally, counsel. I'm not talking about
Hold
you
on
personally.
one second, Attorney Henderson. Go ahead, Attorney Garcia.
Again, all of those are evidentiary issues. If I can't prove them at trial, then the court doesn't find Ms. Pollen in contempt. Simple as that.
Okay, Attorney Henderson. I always get it. Is it Henderson Love or Love Henderson?
It's Henderson Love, Judge.
Henderson Love. Okay, go ahead and proceed with your special exceptions.
Thank you, Your Honor.
Can we get a ruling on that first motion before we start with the second one?
I'm reserving my ruling on that one to hear her special exceptions. Go ahead.
Okay, Your Honor, our special exception number 1 is the failure to identify a controlling order for each alleged violation. Moving alleges prior child support arrears as of December 31st, 2021, and seeks contempt based on those arrears, but fails to identify the specific order governing the alleged pre-2021 obligations. Moving please only a December 21, 2021 order, while simultaneously seeking enforcement of obligations that necessarily predates that order. And that's page 210A, Judge. Respondent especially accepts and requests dismissal or alternative for them to replead that each specific order alleged violated, the operative dates of each order, and the obligations imposed by each order. That's number 1. Special exception number 2, Your Honor, improper lump sum arrearage allegations. The movement alleges aggregate arrearage amounts for child support, medical support, and interest without pleading, specific payment due dates, specific dates of non-payment, or the amount due on each alleged violation date. The aggregate totals are insufficient as a matter of law to support contempt. Respondent specifically accepts and requests dismissal or with prejudice or alternative that the movement be required to replete each alleged violation with a specific due date, the amount due on that date, and the amount, if any, paid or credited. Special exception number 3, improper reliance on Exhibit C to cure pleading defects. Movement attempts to incorporate a payment registry record by reference without attaching Exhibit C, while reserving the right to update the record at or before trial. A respondent cannot be required to defend against contempt based on documents that are not pled with specificity and expressly subject to change. In the motion, Mr. Garcia says that it's subject to change, and he'll update it as he goes. Respondents especially accept that and request the movement to allege violations within the body of the motion itself without reliance on future or amendable exhibits. Special exception number 4, failure to specify individual dates of contempt. The first amended motion fatally fails to meet the statutory requirements by providing only aggregate arrears calculations rather than the mandated date-specific information. The motion states that the respondent is in contempt of Your Honor, as in contempt of court for failing to pay the full amount of the current child support due from December 31st, 2021 through February 1, 2025, but provides only cumulative totals. This broad allegation spanning over 3 years without specific dates violates the express requirements that the motion must specify each date of alleged contempt, the amount due, and the amount paid. Special exception number 5, Judge, failure to plead ability to pay. Non-payment alone does not constitute contempt. Ability to pay is required element when incarceration is sought. And special exception number 6, internally inconsistent pleading, contempt versus a clarification. The motion simultaneously seeks contempt and incarceration while requesting that the court issue a clarification order if the underlying support order is not specific enough to be enforced by contempt. The order that requires clarification is by definition insufficiently specific to support contempt. So therefore, we ask Your Honor that we specially accept to this inconsistency and request that the court require them to repeat accordingly.
Thank you, Counsel. Attorney Garcia.
Okay, on some of these, I don't even understand what she's saying. I'm not seeking contempt on a lump sum. I'm seeking contempt on dates after the court rendered a judgment for arrearages in December of 2021 for payments missed. There is no payment I'm sorry, there's nothing I'm seeking on a lump sum. I don't even know what that's about. And then for this third one about using to cure pleading defects, I don't even know how to respond to some of this because I don't understand what she's saying. And I'm seeking contempt on aggregate arrears. I'm not seeking contempt on aggregate arrears. The other thing about I have to show that her client has the ability to pay. Nowhere in the family code does it say that. The only thing close to that is if they raise an affirmative defense, they're supposed to raise it. I'm not seeking contempt on something that the court needs to clarify. It says if the prior order needs to be clarified and cannot be supported by contempt, then the court needs to clarify it. I think my response says it all. I mean, there's just none of those, all of those are red herrings or they're evidentiary issues to be raised at trial. I mean, none of those, she wants me to replete something that it's just impossible. No one would ever be able to file an enforcement action the way Ms. Henderson Love is asking the court to have me replete. No one. It's impossible. And that's why I raised that case in the very beginning of my response, Judge, because again, the appellant raised pleading defects or pleading sorry, in his appeal, said that the AG's pleading was not sufficient under 157, and the court went through it and said it is sufficient. And basically, my pleading mirrors theirs. I don't know what else to say.
Basically, your case, I think the judge hit on that from the very beginning. It's two-part. It says in the motion, in the motion, and you can add that pay record. But I don't even think that's the most critical part. I think, how do you get to the aggregate amount? And when I use the term aggregate, I want to be clear, is that amount that's being requested of the 21,000, that aggregate amount, and where does it come from?
Okay, you're conflating my seeking a judgment for arrearages with contempt. Two separate issues.
You filed a motion for enforcement for contempt.
I know, but I'm also seeking.
So, hold on. You all don't have to go back and forth. Attorney Garcia, on your motion for enforcement, specifically on page 2.
Hang on, Judge. Let me pull it up.
Okay.
Page 2. Okay.
Okay. So I guess I'm just going through what I read in the special exceptions. It says on December 21st, 2021, in an order entitled Order Ensued to Modify Parent-Child Relationship, court order respondent to pay the $900, right? And that's supposed to begin January 1st, 2022.
Correct.
All right. So on number 8, it also starts out with similar language. On December 21st, in an order entitled Order of Enforcement by Contempt, judgment was granted to obligee against respondent for child support arrearage. Are those two different orders?
Yes. And if you see, Exhibit A is the first one you referenced, and Exhibit B is the second one you referenced.
Okay. So under each, I guess the court is confused why it would be, I don't know. Wouldn't it's the same obligee and obligor, right?
Yes.
So I guess the court is confused of why they weren't, if it's a suit to modify the enforcement, why weren't they put together?
I don't know. I wasn't a party to those suits.
Okay. I can see where the confusion lies, because then it also goes down to number 9, and it's the same date with I guess this is the same order that's on number 7.
Yes. Apparently 2 suits were brought up, I guess, at the same time. And at the end, the 2 suits were entered at the same time. One of them was a modification and one of them was a confirmation of arrears. And court confirmed arrears on Exhibit B.
But then you have it as an order of enforcement, not a confirmation of arrears.
I didn't title it. They did. I'm just referencing what the title is.
But if he's not sure,
and I guess that would be the issue. Well, because
I can't help
order,
I can't help what the title
that wouldn't be your fault either, because you didn't draft. I mean, it's not mine either. I wasn't the judge at that time. So it's not anyone's fault. It's just one of those things where, in terms of enforcing it, enforceability,
it doesn't
affect
the
issue.
The title doesn't affect the enforceability of the order. And I'm not, again, I'm not.
The title doesn't.
Yeah. But
in terms of enforceability, with outlining what the arrearages are, I could see that being the issue.
Again, I'm not seeking contempt on the arrearages. I'm seeking contempt on payments due and missed after the arrearage was entered, after the court confirmed the arrearage.
Your Honor, that's not what he pled.
Yes, it is what I pled.
It says,
if you look down on.
May I read, Your Honor? On page 2, number
we can all read, Miss.
I'm not, Mr. Garcia.
Okay, you all do not
I'm
have
not
to
doing
go
that.
back and forth.
Yeah.
This is not either of your case, so
Yeah.
it's nothing to be taken
Yeah.
offensive.
Thank you, Your Honor. And I just want to clarify that. I'm not trying to say you personally. I'm just trying to represent my client. Okay.
I know.
Okay.
I
So
apologize.
number 10, it says respondent has violated the orders described below. And A, respondent is in contempt of court for failing to pay the full amount of current child support due as referenced below. And then it goes into that. So I just want to clarify why we made that
Yes.
argument.
See Exhibit C. Exhibit C is where the payments are, it shows the amount due, the payment due dates, the payments made, the payments missed, and the balance. And again, that case I cited in my response says that is sufficient under 157.
Okay, I don't know
And if it
about
was
that.
if it was sufficient then, it's sufficient now. And that was an AG pleading. This is an AG pleading.
Well, AG pleadings, that doesn't mean that they're always right. And
Right. I don't disagree with that, but if they're wrong, then you won't find her in contempt at trial. But this is just to give her notice, and she's got notice. I mean, you're trying to strike, I mean, not you, but Ms. Paul is trying to get a pleading struck on evidentiary issues that are not yet before the court.
Well, in order for me to even entertain contempt or anything like that, I have to have a pleading that's sufficient before me, that's where I'm able to grant any relief for what your client is seeking, Attorney Garcia. And from what I am looking at, and despite the confusion, right, in whatever the language may be in the order, I think specifically the language of 157.002, where it specifically talks about if you want to hold someone in contempt, what must be outlined, that's just not in this motion. And the court is going to grant the special exceptions in regards to what 157.02 says about the contempt language and allow you to replead.
Which one? Which special exception are you granting?
Let me tell you the exact number. It is, where'd it go? I think it's 3. Attorney Henderson Love, is that the one?
Yeah, it would be.
Oh, there it is. It's number.
The lumps, well, number 1 would be, Your Honor, the failing to identify the controlling order. That's number 1. And number 2,
it's not that one.
And number 2 is a lump sum arrearage allegation.
I'm not seeking contempt on a lump sum.
It's I'm not granting on that. It's under special exceptions number 2 about the specific date, the amount due, and amount, if any, paid or credited. So it falls under special exceptions number 2. So that's what I'm granting the special exceptions on.
Are you basically saying that you want me to incorporate the pay record into the motion?
I'm just saying that I'm following 157.002 and what it says specifically about trying to hold someone in contempt. I can't necessarily tell you how to plead it, but that goes in line with Slavin. You have to track the language specifically with contempt. You have to show the amount paid, the amount due, the date, the amount due, the amount paid, if any, and any arrearages. So I reset you all.
Do I have to serve her
my
again?
contempt? Now that in the family code talks about that too. You do not have to do service again.
Okay.
That's in the not the family code, that's in the actual handbook that mentions she does not have to be served again after a special exceptions has been granted. So I can just go ahead and reset the motion for enforcement, and it will be on a Monday.
So I'm sorry, special exception number what was granted?
Number 2, but don't look at, so let me clarify, Attorney
Okay.
Garcia, don't look at the first portion where it says improper lump sum arrears. It's not that, it's right underneath that, but it's incorporated under number 2. It starts with respondent specifically accepts and requests dismissal with prejudice, or alternatively that movement be required to replead each alleged violation with. So Attorney Henderson Love, if you would do me an order that just has that language specifically, so Attorney Garcia isn't confused and thinking that I'm talking about the lump sum aggregate, that would be great.
Yes,
And
Your
so
Honor.
are all the other special exceptions denied?
I didn't say that. The court is only entertaining that one.
Well, can I get a ruling on the other ones?
Nope. The court is only, especially, the court is only sustaining that one.
Okay.
And Your Honor, do you want us to, you've already given us a date, I believe, for the next hearing?
Well, I'm waiting to see which dates. Well, the best way to do it is to see which days don't work for you all.
Yeah, my Mondays are crowded now. Oh, sorry, I'm looking at the wrong year.
And what months are you looking in, Judge?
March.
Okay, okay.
March and April. I mean, March is right around the corner, so April
Yeah.
is fair.
Okay.
And let me call my coordinator just to make sure I don't double book anything. Hold on one second.
Judge, you have either April 20th or 27th?
You said April?
Yes.
I can do the 20th.
April 20th?
That is available.
That's available.
Okay. Are you in person?
If it'll be in, it's up to you all. If there's no objection to Zoom, it can be on Zoom, but I think since you're asking for contempt, it probably should be in person.
Yes. Miss Pasquini, is April 20 good for you? You're on mute. You're on mute.
I'll send you a prompt, Attorney Pasquini, so you can, it'll ask you to unmute. Did you see the prompt where it says?
Yes,
There
now
it
I got
goes.
it. I'm sorry, I couldn't get it to work. April 20 is fine with me. I will only assume or hope that it's fine with Dr. White, since it's far enough out that he could move clients, patients.
And if necessary, we can start early like we did this morning. If you all want to do 8, you want to do 8:30, I'm open to that.
If we're in person, Judge, that's kind of, if you're all okay, I would prefer the later, the 9.
Yeah, that's a little early for me.
Yeah.
It's a little
Well,
early
it
for
was-
me to get in there.
I just wanted to throw that out there.
Thank you, Judge.
You're welcome. So 9 a.m.?
Yes, Judge.
That's good.
Okay. Okay, Bree, 9
Thanks,
a.m.
Melodies.
No.
Okay. All right. Well, we have it set. Miss Pollen, let me get you sworn back in for that date. I sent you a prompt to unmute and start your video.
Your Honor, can you hear me okay?
Yes, I can hear you. Did you see the prompt to start your video? There you go.
Hi, can you hear me okay?
I can, I just can't see you. There you go.
There you go. Sorry about that.
That's okay. Raise your right hand.
Mhm.
Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
Yes, I do.
Okay, you may lower your hand. We are resetting this case for April the 20th, 2026 at 9:00 a.m. You are ordered to
Okay.
appear in person. You're ordered to appear here in person at the George Allen Courts building located at 600 Commerce Street, 4th floor, the 255th District Court, Dallas, Texas, 75202, the exact same courtroom you were in on Monday. Your failure to appear may result in a capious warrant being issued for your arrest. Do you understand that?
I understand.
Okay, do you have any questions about those instructions?
No.
Okay, thank you. Is there anything further for the record?
Nothing from respondent, Your Honor.
Nothing for moving.
Okay, well, thank you all and have a good weekend.
In this deeply moving and unexpectedly heartwarming custody hearing, a father named James walks into court having raised his 2 children completely alone for 8 years, after their mother, Sandra, simply walked out of their lives without explanation, leaving him to handle school runs, doctor appointments, homework, birthdays, and every single moment of their childhood entirely by himself. Sandra now reappears after nearly a decade of absence, claiming she has turned her life around, secured stable housing and employment, completed therapy, and deserves equal parenting time with the children she abandoned. James arrives with 8 years of documentation, school records showing perfect attendance he maintained alone, medical records showing every appointment he attended without Sandra, and most powerfully letters from both children's teachers describing him as the most dedicated and present parent they have ever encountered. Sandra's attorney makes a sympathetic case for gradual reintroduction, acknowledging the absence but arguing that children deserve relationships with both parents regardless of past mistakes. Judge Simpson listens carefully to both sides before delivering a beautifully balanced ruling, acknowledging Sandra's genuine efforts to rebuild her life while making clear that 8 years of absence cannot be erased overnight, ordering a carefully structured reintroduction plan starting with supervised visits of 2 hours per week, gradually increasing based on the children's comfort level and a therapist's recommendation, and firmly denying equal parenting time until Sandra demonstrates sustained commitment over at least 1 full year, closing by reminding both parents that the only timeline that matters is the one that makes their children feel safe.